Welcome to the panel on law and computer science. In this panel, we were going to have 3 speakers, but we only have 2. Just a minute. Our panelists got an equal question, and I'm going to ask you to present your view on this on these 2 questions, whichever you want to answer. If you only have an answer to one of them, that's fine. Which is, what are the challenges that computer science poses on law, and what are the challenges that law poses on computer science? As I imagine it, the law people will have a lot of challenges for the computer science, and the other way around, but maybe I'm mistaken. So let me introduce the speakers. Just a minute. So we just heard from, okay, I have my text. We just heard a bit from our first speaker, who is Professor Niva Elkin-Koren. She's Israeli. She's a professor of law at the Tel-Aviv University Faculty of Law and the faculty associate at the Berkman Klein Center for Internet and Society at Harvard University. She's a former dean of University of Haifa Faculty of Law and the founding director of the Center for Cyber Law and Policy and the Haifa Center for Law and Technology. So as you can see, she's like GECON, very much into the interdisciplinary stuff. Her research focuses on innovation policy and access to knowledge, digital governance, online intermediaries, and the legal implications of AI and big data. And as I said, she is also one of the founders of the Israel Privacy NPO. And we also have with us Supreeth Shastri. He's an assistant professor of computer science at the University of Iowa. He received his PhD from University of Massachusetts at Amherst and was a postdoctoral fellow at the University of Texas at Austin. His current research explores how computing systems are influenced by emerging data protecting regulations such as the GDPR, which might be of interest to the Europeans among you, and builds software infrastructure to manage their impact. His work has been adopted across industry and academia and integrated into teaching at a dozen universities. So would you like, who would like to start? Or I will choose. Niva, can you start, please?
Right, I can start.
Thank you.
So thank you very much for the invitation to this forum. As you've said, Orna, these are questions that I've been thinking about for a very long time, but also I really like the way you framed the questions to the panelists, because it really inspired me to think of, to reflect on some of the work or even the interdisciplinary work that we are doing. And sort of the first question was where must computer scientists stretch their ability to provide law with adequate solutions? And on first take, it felt like, oh, this is a great opportunity to have my wish list for computer scientists. And I had many, there are many items on this wish list, but actually I wanted to say something that is more general and a little bit more abstract about what I feel is necessary as we are shifting into algorithmic decision making and substituting human decision makers with automated systems. And I what I'd like to ask computer scientists in a nutshell is to enable processes where norms can actually evolve. And I'd like to explain what I mean by that. And so in law, we focus routinely on the challenge of governing behavior of individuals and communities. And a lot of legal scholars have recognized as early as the 90s, with the internet and digital revolution, the important role of algorithms in governing behavior of people too. And so people like Joel Reidenberg, who passed away unfortunately last year, but also Larry Lessig, were talking about code as law and governing behavior with algorithm, but all of them also recognize the difference in which we govern behavior, the distinct ways in which law is governing behavior and design is governing behavior. And in law, we actually govern behavior by setting a norm and setting up a sanction, and leaving it up to the user or to the citizen, to the consumer, to actually direct their own behavior. Whereas with algorithms, we create affordances. We define by systems what people can or cannot do. We create barriers if we want to nudge the behavior in one direction or another. In law, what we have is these norms do or do not do, and the sanction for violating the norm. And what is really interesting for this discussion, I think, is that we have two types of norms. We have norms, generally speaking, that we call rules, and these are more in compliant with thinking in computer science, I believe. And these are norms, these norms that we call rule will actually describe circumstances and outcomes. So a classic example will be do not exceed the speed of, the speed limit, like 90 kilometers per hour, or else get a fine. So this is the do and do not do, and there is the sanction. But, and I think that these are relatively easy to automate because it's the if X, then Y, right? This is sort of rule-based. The problems start with what we called in law standards or principles or open-ended standards, where we actually require a decision maker to exercise discretion. And that is where there is a norm that would say, you need to conduct your business affairs with good faith or negotiate with good faith. What does good faith mean? It would mean what a judge would decide ex post based on the case law, and there'll be some disputes regarding what the standard means, whether it's a subjective standard that takes into account intentions or awareness or knowledge, or whether this is just an objective standard. What did the case law before said? How does it apply to particular circumstances? And lots of open-ended discretion. And as we shift to automated governance, I think we need to enable some dynamic development of law through these standards, because what they fulfill is a really important role in how we shape our norms in society. Like, Orr just concluded his talk by saying that technology is shaping society, and I think that is right. And as we assign technology with this role, we should have some ways in which we enable not just rules, but also standards. So let me just demonstrate this in a particular context of content moderation. When you look at social media platforms, for instance, where they, the simplest task they need to do is to moderate content, to sometimes filter harmful content. And the basic thing was to filter that they've done actually since the late 90s or the beginning of the year, like over the past 20 years, is to filter out copyright infringement. That was supposed to be a real simple task, like using a hashtag and seeing whether, identifying the copyrighted works that are similar, substantially similar to an original work of authorship, where that would constitute a copyright infringement. That is, of course, such systems would also, of course, implement some judicial discretion, because what is substantially similar is something that a judge would decide whether my original copyrighted work is similar enough to a copy, like a remix. That is a judicial decision. But you can make a decision to say 20% is enough, or 30%, or the first 3 seconds of a video that was uploaded to YouTube, that would be enough. What is more difficult is once you think of exceptions and limitations to copyright. Not every copy is a copyright infringement, legally speaking, because sometimes there are exceptions in law, and these exceptions could be rules. That is when we know ahead of time what it is that we want to exempt, like some educational use or some uses that are non-voluntary or part of a process, right? In computer, like in computer, with respect to computer software, if you make a copy in order to, if it's a backup copy, we can say, well, a backup copy is not really a copy, so this should be exempted. That makes sense. But some cases, we cannot know in advance what we want to exempt, especially when we don't know what would be the future uses of an original work of authorship. And in that case, we have some open standards, such as fair use. This is a standard that we have in Israel or in the United States. And when we talk about an open-ended norm like fair use, it says something like, fair use of a work is permitted for purposes such as, and now comes an open-ended list: private study, research, criticism, journalism. But also it says that in determining whether something is fair use or not, the court would have to decide ex post 4 factors: the purpose and character of the use, the character of the work that was copied, the scope of use, both quantitatively and qualitatively, and also, of course, the impact on the potential market for the work. All of these have to be considered and weighed in a particular case. And the big challenge for these content moderation filters, that, by the way, in Europe, just as an example, for instance, were just written down into the new copyright directive that was passed last year. So that social media platform actually, by law, have to apply some automated filters of that sort. How could we implement such automated flagging, not only of infringements, but also of fair use? I think that is a big challenge. And just to at least conclude this point on the first question, the reason is that this is really important. And again, fair use is just an example, but also free speech is an example, and good faith is an example. And other instances where we either don't know what would be the uses that we want to exempt, or more importantly, and that is actually maybe a broader point that I'd like to make, is that sometimes we disagree now on what it is that we want to prevent. So think, for instance, just to give an example, following on Ora's great presentation, there are lots of issues on which we disagree, right? What is fake news now when people discuss vaccines? We each have our own ideas about this, right? But when we tell Twitter and Facebook, you need to filter out all these fake news or disinformation, they need to implement this into the automated filters. But in law, we don't have that same problem, because we can say you should not, we can have a rule, you should not disseminate fake news, or you should not disseminate disinformation. And we can have an attached sanction to that. But we do not have to decide right now what is considered disinformation. A judge can decide it in the future related to particular cases, right? How do we create this space for negotiating norms and creating some ambivalence and enabling deliberation of some contestation and discussion on norms when we build the systems that would moderate our content and actually shape our public sphere? That is where I see the biggest challenge. So I can stop here. Maybe we can all discuss.
Yes,
first point.
I think this would be a good point to move to Supreeth Shastri, because this relates to one of the things that I read in one of his papers about the GDPR. The fact that when we use AI, then the European law requires that the AI would be able to explain how it got to this conclusion. So if we had an AI, for example, assisting judges or assisting law assistants in their legal research, they would have not just the final result that the AI thinks that this is not fair use, but it would also have the reasoning. So Supreeth, maybe you would like to take it from here?
Yes, absolutely. So good morning, good evening, everybody. So I'm honored to be in this eminent company. Yeah, I think so that was excellent beginning by Niva as well. So really looking forward to engaging with her. But to first answer this question from my vantage point, right? So I'm a computer scientist. I'm in fact an experimental computer scientist. So I build systems, I measure what they do, I observe them in the real world, and then try to extract principles and practices that can be systematized, right? So my answer is going to be based on, to keep them concrete, on a specific regulation, which is a data protection regulation from Europe called the GDPR, or the General Data Protection Regulation. I mean, most of the audience would have heard the word GDPR, if not really deeply know about it. And that kind of exposure is enough to kind of understand my points or the gripes about this. So I want to base it on, make points at two different points. One is, so what must the computer scientists do, right? To where must they contribute to help law with adequate solutions? So the first is understanding the present, right? And the second is driving the future. So let me just expand on each of those. Understanding the present means, so the view of things from a legal perspective is quite different, as I think Niva mentioned. They can be abstract, they tend to be abstract. And whereas in the computing world, if you switch over to the computing world, we excel in specifics, right? So when you build a system, the computing folks are trained to build to a specification, right? So we are really good at it, right? So there is a inherent tussle between the two, the law and the computing. One, if you read a law article or actually a regulation, you tend to feel it's really abstract. It doesn't get into specifics, right? It's left to the interpretation of the judicial system, right? So that leads to a conflict, right? So what can the computer scientists do to to diffuse this tussle, first thing is to provide, cold hard facts and the empirical data about how, in this case, specific case, GDPR affects your systems, right? So let me actually give an example. So one of the projects that we did a couple of years back was to take GDPR and then ask, how does it impact databases, right? So databases happen to be just one of those areas which is affected by GDPR, which is a data regulation, because you store your data in the database, right? So we went on to this question as to ask, how does GDPR affect databases? As it happens, many of the features or many of the requirements from GDPR, such as encrypting data, being able to monitor and log the activities that happen on the database, they already exist in the databases, right? But when you actually turn on those things in the real world, in the production systems, your performance takes a nosedive. Okay, so just enabling these features that already exist, that have existed for decades, brings down the performance significantly. Using concrete examples like Redis and Postgres, which are quite widely and popularly deployed database systems, we show that even doing this basic feature level enabling drives down the performance up to 80%, right? So that means if you're having a database now, your cost of databases could go up by 4x. Okay, so if you're spending $1 million, be ready to spend $5 million just by enabling the features that already exist, right? That's kind of unacceptable to many people. Maybe the Googles and the Facebooks can, quadruple and quintuple their investment, but it's not easy for the mom and pop stores to kind of do that. It's very expensive, right? So this is a useful data for the regulators to have. Okay, so just because you're not doing encryption of your entire database doesn't mean you're a bad person. It just means that it's very expensive and you cannot afford it, right? So that brings in the notion of the context and personal data, being able to separate the personal data from non-personal data, right? Which people are not used to do. You keep all your data in the database, right? So that brings in more nuanced arguments about it. And to get to that argument, we need this data, which simply says, if you have a database and if you're trying to comply with GDPR, you need to do this bunch of things, right? So we identified a set of things. And we showed that there are two things. One is data. You need to do certain things with the data, keep extra bits of information to fulfill people's rights. Like if somebody says, if Niva comes to me and says, I'm a provider of a service, and she says, delete my data, right? The famous right to be forgotten. Then I need to be able to pick up all the data that I have collected about Niva, right? So this ability to identify the information that belongs to a person, right? And remember the context in which we collected it, like the purpose. So all this metadata, if we store with the data, there's a ballooning effect, right? So I have the data and I have this metadata. I need this metadata to honor people's rights, data rights. So the first thing that GDPR does to a database is balloon the information that I store, right? And the second thing is, in real time, I need to track what am I doing with Niva's data, right? I'm using this for advertising purposes. I'm using for security purposes. I need to track all of those, right? I'm also leaking the data. I'm sharing it with somebody that I'm not supposed to share. So you need to do all of this, right? When you enable this logging, monitoring, and encryption in real time, again, the performance goes down, right? We need numbers for this, right? If you want to make a case saying that, okay, this affects my performance, this affects my ability to store, this regulation is a heavy footprint, you need the data, right? So that was just an example with GDPR, intersection of GDPR with database technologies, right? Now you can think about what other technologies exist in the world. So you have networks, the internet, you have the IoT systems, you have mobile systems like the phones, you have AI ML systems that are now brought into the discussion earlier. You have robotics, right? So, and there is an intersection of many of these subfields.
I'm trying to link what you're saying to that question. So what you're actually saying is that what a computer scientists need for the law people is to actually the economy. You need to quantize how much it costs, and don't make laws that are unfeasible economically, right?
Correct. Yeah, I think there's a subtle difference that I would just like highlight. This is absolutely correct what Orna said. So I think my gripe would not be at the level of making the regulation. I think the regulations, as Niva also mentioned, tend to be abstract. So they're open to interpretation. So I think I would target this argument to the judicial system when they actually do rule on these things. They need to take into consideration the hard facts on the ground, how the law actually impacts the deployed systems, and then make judgments, right? So the enforcements definitely need to take into account. I would also urge the lawmakers to be, familiar with the technologies that they're trying to regulate at the least. Yeah, so I think that's a high level point. So let me just finish with the second point, which I wanted to make, which is, so this is understanding the present, right? So we have these deployed systems, and how do they how do they get impacted by the law? Second is, we can drive the future. So from what I've seen in my short experience is that computer scientists tend to check out of this whole regulation process. They consider it very messy, and it's multi-stakeholder. It's not as simple as building a system and just putting it out in the world, right? So they tend to have checked out the process, and they come in only when somebody tells, is your system GDPR compliant? And that's much later, right? So instead, we can actually contribute by being part of this and driving the future. And one example is, so GDPR requires us to do a bunch of things, right? For the good of the society, right? So one of that is, if you encounter a data breach, and if you detect it, you're supposed to inform the regulators and the people affected in a decent amount of time, okay? And they actually even specify that it should be like something like 72 hours, okay? So if you come to know of your data breach in your system within 72 hours, you should inform the relevant people, okay? And it seems like a lot of time, right? But before GDPR, people were doing a lot of goofy stuff, right? There's this famous case of Uber trying to, appease the hackers by paying them the ransom and all that. So you're not supposed to do any of that, right? You're just supposed to let people know that data was breached and these people were affected, right? So as it happens, it's not really easy to detect that, right? Because as the systems get huge, data can leak from any part of your system and you won't even know it if you don't have fine-grained monitoring, right? So if you look at the cloud, so basically we do all our compute in the cloud these days, right? So if you look at the cloud and say, okay, well, I want to implement this. I'm a good intentioned person. I want to implement this support for breach detection. So where is the solution for that? So I'm going to buy the solution on the cloud. Do you think the solution exists on the cloud? Absolutely not, right? So what the cloud is currently doing is giving you these low-level mechanisms, such as monitoring and logging, access control. They give you all of this, which are really, really low-level control. So on top of that, you need to build everything by yourself, right? So you need to define, what is a data breach for your system. And once you detect the data breach system, you need to identify all the people that are affected, which is not easy, right? And then you need to do all this investigation about where it went, how the data was leaked, so on and so forth. So there is no service for that, right? And I can imagine if that were to be provided as a service, like for example, think of this GDPR compliance as a service, right? So you as an organization bring in some policies, and then cloud providers actually help you plug in those policies into this stack of operations that they build, and boom, you got your GDPR compliance ready to go, right? That'd be so convenient for non-technologically focused organizations. I keep thinking about the mom and pop stores who cannot hire lawyers and who cannot hire compliance engineers to get this done, right? So that's something that I think computer scientists can really work on, to make technologies, like provide services that make GDPR compliance easier on people. We are not doing that either. So I think that's something to be done in the future, along with understanding our present well. So yeah, so let me just take a pause here and then give the floor back to Orna.
Okay, thank you. So we have another requirement from the computer science people again, to enable the simple person in the store to follow the GDPR. What about the other side? What you started with making the law people being aware of the costs. What else does computer science want from the law? And this is, I'm opening the question because it seems to me like none of you prepared an answer for this. Am I right, Niva?
No, I mean, I looked at the way, you know, at what I see, where I think the law should actually adjust to some of the challenges in computer science. Yeah, I do have some thoughts about this. And so just to put it in context, just before I say that, I think if there are questions or comments, I know that we only have like 15 minutes for this plan, and
we started late, and
no, but I'm afraid I have to leave at noon Israel sharp, so
okay.
I cannot stay longer, unfortunately. So if there are questions, this is the time to raise it. But I think from a legal perspective, it's really interesting. So the law, especially common law, that is common in common law countries. Israel also follows the common law in many ways, but definitely the UK and the United States. The law has a built-in mechanism for adjusting to new technologies, because this is what the courts are doing. So you have like a law that defines liability for car accidents, and then a judge would have to decide whether it also applies to drones, whether it also applies to autonomous cars, whether it applies to wheelchair. When do you, how do you interpret it when there is a technological change? But then there are sometimes disruptive technologies, right? So that requires us to rethink the way our legal system work and how we actually articulated and framed the problem. And so I can give examples of a few challenges that we have now. One is, I think, only part of a challenge, but I think it is interesting, and it's like it's controversial among legal scholars, and that has to do with non-fungible tokens and copyright. And so a lot of people are just thinking that this is the end of copyright, because in copyright law, we protect works of authorship like music and pictures, because we sort of assume that if someone is investing in it and then someone else can just copy it and there is no return on your investment, no one will actually invest in developing it, right? The same would go for software. But if you can actually use blockchain in order to somehow record the transaction and create some ownership that cannot be transferred or duplicate, maybe that is solving the problem of copyright, and maybe we no longer need copyright. Of course, I'm sure that since there are many crypto people in the room, I bet many of you are more skeptical about this and think, there are many ways in which the NFTs are not recording the work itself. It's only a link, it's only recording the transaction. And also there are many ways in which you can do the minting by someone else that is not the author. And therefore there is still a role for the law, but maybe not the same role that we used to have for copyright, that is just giving you exclusive right to copy and prevent others from copying. So this is just an example of where maybe the law has to adjust to a new phenomena in a way that doesn't let us just say, okay, judge, just decide whether it also applies to NFTs. No, this requires a whole paradigm change if that is indeed preventing some, copying, because it changes the nature of a work of authorship. Just to give another example from liability. So in liability, we usually look for the one who is responsible for the harm, right, and put liability on them in order to deter them from committing further harm and provide incentives for others to take precautions and prevent the harm. But when we look at machine learning systems, especially this debate is arising with respect to autonomous cars, then there are lots of stakeholders that are involved in this development. And so you have the one who developed the model and the one who did the training and using maybe distorted data or partial data. And you have the one who is deploying the system. And how do we divide the liability among them? That is like a major issue now in a lot of these machine learning systems. But there is also another fundamental problem or challenge for liability rules that is raised from a concept that we're using in tort law, that is reasonable care. So you know that when a patient dies, unfortunately, in a hospital, right? It's not necessarily the doctor to be blamed, only if the doctor was negligent. So they did not exercise reasonable care. But what would be a reasonable care? That would be something that doctors or physicians in his situations actually are expected to undertake. Now, I had a PhD student that Carney, now she's a doctor, Dr. Carney Chagall already, after her PhD was approved. She wrote about the reasonable algorithm, thinking about situations where actually expert systems have to be, to meet a standard that is a standard of care of professionals, where we don't necessarily want to hold the system or the developers or the producers of these systems accountable for any harm, because they have to make, if it's a robo-doctor, right, or if it's a system that is being used in a hospital, sometimes we need to tolerate some level of error, and some would be reasonable and some would not be reasonable. And in law now, we don't have a good system that would enable us to define the standards for the reasonable algorithm. So this is like a second example. And a third example, I talked about, I was trying to ask you in computer science to actually think of dynamic ways in order to negotiate legal standards. And I think that the same goes to the law. And so in law, we also think about fixed products. Like, for instance, we have a system of certification. We think there is a product, we certify it, and then it is ready to use. But as we, just to give example, we think of cars, right? We have to license a car. We have to get a license, right, in order to put a car on the road. Or in books, we normally, the educational boards or the Ministry of Education in some countries would actually approve a book to be used in schools. Not every book can be used, right? And so there are different mechanisms in different countries in order to approve what is a certified book. But if you look at learning systems that are actually digital books that are actually learning and changing as they are being used by a class or by students, it's meaningless to certify it ex ante, because what you provided the educational board or the Ministry of Education ahead of time is no longer the product. The product is actually a learning process. It's dynamic. And in law, we have to think of other ways of overseeing these products and making sure, auditing it and making sure it is still in compliance with some standards, but on an ongoing basis. Certification ex ante is no longer useful. So these are just a very few examples of the many challenges that the new technologies are bringing to the law.
Okay, thank you. This brings to mind some thoughts, for example, about the use of Wikipedia in schools. It's not a law, but the sort of law at school is that you don't use Wikipedia because it's unreliable, etc. But in the end, Wikipedia holds a lot of the information. The encyclopedias are authorized, but not updated. And this is the best source of information. So they're teaching the children not to use the best source of information instead of using, as you said, the process, which is to check and evaluate how good this specific Wikipedia article is.
Yeah, I think this is a very good example of where it doesn't make sense to say don't use Wikipedia. It's just like it's a bad rule. I think the rule should be, yeah, knowledge is something that is controversial. It's evolving. Wikipedia is a wonderful example of where you can have more transparent example of how knowledge could be subject to debate, because you can actually see the corrections and the editing and the process. And you can ask your students to engage in these editorial processes and understand where the controversies are and become more critical about any source, not just Wikipedia, any source that they're using, and think for themselves what they can trust or not.
Yes, indeed. Supreeth, would you like to add to this other side of the coin?
Yeah, I just had a brief point. I think I'm not a trained practitioner of law, so I'm just commenting this as an informed outsider. Okay, so I'm the CS person. I'm looking at this wonderful law people making all these laws, and it's absolutely the right time, and it's a good time to actually do these things. For example, GDPR, I think it just brought in an era of responsibility about data rights, right? So if I look at Europe now, what's happening? Basically, Europe always leads in these things. They're coming up with the Digital Services Act and the Digital Markets Act, right? So they're trying to regulate how these cloud services and these digital services like the Facebook and the Twitter and all these. So they're creating their market of their own, and they are largely unregulated, like the Wild West. They're trying to bring in some order, which is absolutely needed. I mean, as a society, we agree that's the reason why they're doing. But as a computer scientist, who's like sort of observing from outside, when I see this, I have at least like two high-level problems, right? One is the broad interpretability, which I think Niva expressed, right? So the law is written to be interpretable, whereas the computer systems that are developed to a particular specification. So that tussle needs to be resolved in sort of, at the time of enforcement, right? So you cannot write laws about what is or isn't a fake news, for example, right? To borrow an example from Niva again. But when you actually enforce it, there needs to be much more clarity or the straightforwardness in what to expect, right? So we are doing currently a project where we're trying to analyze, there are 3 years of GDPR has already happened, and we were collecting all those decisions that have come out and then trying to see, can we get any pattern out of it, right? Because if I were to advise some company as to what practices do they need to do for GDPR going ahead so that they don't get fined, what do I recommend, right? So we're trying to look at all these regulations, sorry, not the regulation, the enforcements and the decisions from the courts and such. And we see wide range of diverse outcomes, okay? And the way we see it is Europe is basically a practically sort of, bunch of states put together, and each state has their own data protection authority, which is a regulator, right? And you can see from the news too, right? Like Ireland has their own mind, they regulated their own pace, their own preferences, and it doesn't really match what Germany or France does. So as a company that operates in all these markets, it's very uncomfortable for me, right? So I don't have a separate product for all of these. I have one product, right? So Twitter is just one product. I might have tweaked some algorithms for each country, but as such, I have one product. I would expect more predictable outcomes when these things go to court. And that's, I think, one of the hard things, right? I'm not saying that the Amazons and the Googles cannot navigate this. They can, and they will, and they can even lobby. But for smaller startups and the smaller companies, the mom and pop stores, which want to do business in multiple jurisdictions, I think this non-uniformity in the enforcement of the law brings a whole new set of challenges, so at least the ones that the computing people are not used to, right? We are just used to building one system that kind of is optimized globally, and then we'll just deploy it, right? And I think that's where I think my highest level concern is, that somehow the legal community should address, right? So this is not like the old era where you can actually leave it completely up to the local most judge, because there is a local context involved in interpreting the law, right? So here we are interpreting a system that is globally deployed, right? I think that's something to keep in mind when European regulators try to regulate cloud computing. It's a utility, sure, it needs to be regulated like electricity and water. I understand that, but so there is this like the Brussels effect happening, right? So if Europe comes out with a law, then it becomes a de facto law for the whole world. So please tread carefully, and just like leave some balance for innovation versus the regulation, and just try to make it more predictable for companies. I think that would be my very high level recommendation.
I think maybe this predictability can be achieved using international conventions that will be formed such that there are chapters, and each country can choose which chapter it follows, instead of investing all of the law from scratch.
That would, right? I think that would work quite well. I would assume that would work quite well. But I think the current developments happening is basically, one of the largest markets, which is the United States, is completely checked out of the process, right? For political reasons, for historical reasons. We are somehow not, huge fans of making new laws, or at least the laws that govern our behavior. So we are checked out, right? So what's happening is Europe is basically running away the sprint, taking all these regulations, looking at all these markets. So my expectation is, and if you look at the companies, right? Microsoft last year announced that they will hold the whole world to the GDPR standard. So it's basically, we are heading to that Brussels effect where, Europe law, the law that comes out of Europe sort of becomes a de facto law for the whole world. So I think so that's why I spend my time thinking about European regulations, though I'm based in the US and my funding comes from the US government, because it's a reality, right? So Europe will govern the world in terms of, being responsible behavior, and we just accept it. We have to accept it because, Microsoft is not going to wait for the US government to come out with the regulation. So, so I would just plead to the US lawmakers that, please pay attention to the needs of the technologists. And I think that's where I would hang my hat.
Okay, thank you, Supreeth.
Absolutely.
We will bid farewell to Niva now because I know she needs to go. So thank you so much for...
Thank you. This was a great conversation. I very much enjoyed it. Thank you.
Thank you. And we will open the stage now for anyone else who would like to comment on the subject. Or maybe you'd like to give your 2 cents.
Willing, I'm not sure it's even worth more than 1 cent. So, I can understand why, from technology point of view, we want to have things which are clear in advance, and I think it makes a lot of sense. But I think one of the things that we pride ourselves from technology point of view is that we easily adapt. I mean, I'm not going to mention some development methodologies of run fast, break fast, fix later sort of an approach. And I think that even technologically, I mean, we need to adapt. We need agile programming. We need to be agile. So expecting something from the law experts, like to give us some sort of certainty, I mean, they also don't have certainty because our technology today, I'm looking, for example, at biometrics as an example. Until 2013, 2012, 2013, face recognition was very good. In one-to-one matching, it was extremely good. under controlled conditions, and you could regulate them. If in 2011 people were asked to make rules for biometrics and legal, the laws would have been very simple and very clear. And then suddenly deep learning arrived, and everybody dropped using active appearance model and other techniques that they existed before and moved to deep learning. Everything today is deep learning. Even fingerprint moved to deep learning. Seriously, everything is moving towards deep learning, besides maybe iris, even irises to some extent. So the legal framework cannot adapt to us because we run fast, we break, and then we fix later. And the cycle, and I've seen this as part of discussions in Israel about biometric databases. Speaking with governments and speaking with policymakers, it takes time, even if they understand the technology, even if they know exactly what it means, and they don't necessarily need that most of the time, to be honest. But the processes take time. This is a feature, just like in the US, that you cannot change the constitution. I mean, all the amendments take time, and the process takes time on purpose, because this is a real process. The same goes for some parts of the regulation and the policy making. So there is difference in cultures. That being said, yes, technological proficiency should be increased by everyone, but I think that also legal proficiency by us should increase. I mean, understanding, so we can find better languages.
Okay, thank you. Does anybody else would want to contribute to the discussion?
So may I also say a few things? Vlado here from the University of Ljubljana. Actually, this law type of question and having this technology being prepared to act in advance, I think it's really important. And from the viewpoint of who can do that, I mean, who can give permissions? Of course, in the real world, people can do just anything. But in the computer science world, one can implement all sorts of different mechanisms that can do verification of specific rules, because in the final instance, the law is some sort of a rule book. And if there is a rule book, we can write it also in computer database, for example, we can put it. And whenever we need to make any transactions on the internet, it's also possible to ask for this rule book each time, and to make our programs ask for the permission to do something or not to do in case it's not allowed by the law. So I think probably today in the current internet, this type of mechanisms are not yet well embedded. Like, I mean, even for this contact tracing, so what can be done and what is kind of not allowed to be done, like filming the people in their private space or doing AI on them, or, you know, any sort of these things. So if there is this rule book implemented and shared by everyone, and the people commit to that rule book, then I believe it could be in sometime in the future, maybe not now, but in 20 or 50 years from now, this law will be transformed in some sort of internet book where the systems and services that we use and produce would always be asking this rule book before they decide upon making specific transactions. With this, I believe the internet would embed specific human rights principles that people value, like sustainability or energy efficiency or other things like this. They will embed in this, and I think the internet would become a better place, because there would be less of there would be more privacy on one side, but on the other side there would be more of let's say, safety and ability to share real deep knowledge between the people. So yes, so this is just a commentary from my side. Thanks.
Thank you. I would like to thank all of the participants of this very interesting panel, in particular Supreeth, who got up probably very early for that, right? What's the time there?
Yeah, it's 3 in the morning, but it's good. I am an early morning person anyway, so I'm happy to be up. So this is good.
Okay, I never heard of a morning person at 3 a.m. Thank you so much.
Okay.
And Niva and or I cannot speaker, of course. Thank you very much. And if you want to know who are the winners,